A lawsuit filed at the end of 2020 might very well determine the future of Bitcoin and blockchain technology. The SEC filed a complaint against Ripple Labs and two of its executives on December 22, 2020. According to the lawsuit, they traded $1.3 billion in their cryptocurrency XRP as a security without registering it with the Securities and Exchange Commission. Since then, Ripple and others have replied by claiming that the SEC is prejudiced in its judgment. The current state of the litigation, as well as a breakdown of each side of the argument, may be found below. Claims of the Securities and Exchange Commission, SEC. The SEC asserted that XRP is a security since it was used to fund Ripple's platform, which facilitates money transfers for retailers, in a court action filed at the end of December. The platform's management were also wealthy as a result of the XRP sales. Securities must be registered with the SEC, and some financial information must be publicly reported, according to SEC requirements. The purpose is to protect investors' interests while combating fraud. The Commission uses the Howey test to determine whether a virtual currency is a security, which is based on the Supreme Court's 1946 decision in SEC v. W.J. Howey Company. If an asset is sold with the hope of rewards coming from the work of others, it is considered a security. The Howey test would pass XRP as defined by the SEC in its case. Ripple's reaction: the majority of corporations that are targeted by the SEC in this way settle. However, this is not the case with Ripple. They have decided to battle the SEC rather than comply with its requests. Why? They believe the SEC is biased in its application of the security concept to virtual currency. If this is found to be true, the Commission's authority will be weakened, not to mention the credibility of its argument. Ripple has specifically mentioned some of the links that SEC members have had with other crypto platforms, namely Ethereum. While there is currently no proof of these linkages, the fact that the Commission gave Ethereum a pass on securities legislation while hammering XRP seems suspicious. This is especially true given that Ethereum's operations were initially funded through an initial coin offering, ICO, which is categorically a security. The SEC claims that Ethereum is currently decentralized, disqualifying it from securities regulation. Yet, if this is true, Ripple wonders why XRP is being targeted. It's worth remembering that Ripple was founded with venture financing rather than an ICO, and that it now maintains its operations aren't that different from Ethereum's. Furthermore, Ripple claims they were not given fair warning that what they were doing was illegal under securities legislation. Before launching its complaint, the SEC conceded that no decision had been taken on whether XRP could be classed as a security. Ripple was allegedly selling XRP as an unregistered security, according to the SEC. They believe Ripple's platform is not decentralized because of its participation in funding it. Ripple believes that the SEC classifies companies based on bias rather than merit, or even well-defined rules. They contend that their operations aren't significantly different from those of other platforms that have been granted permission. The litigation is currently in the discovery process, which means that both sides are gathering information to support their respective allegations. It'll probably be years before we have a definitive answer. The Securities and Exchange Commission sued Ripple, its founder and executive chairman Chris Larsen, and CEO Brad Garlinghouse in December, accusing the company of raising $1.3 billion in unregistered digital asset securities, which rocked the crypto and blockchain community. The SEC's case centers on the fact that XRP is a security, not a currency, and thus is subject to rigorous securities rules. Ripple, Larsen, and Garlinghouse failed to register their ongoing offer and sale of billions of XRP to retail investors, according to Stephanie Avakian, then director of the SEC's Enforcement Division. This deprived potential purchasers of adequate disclosures about XRP and Ripple's business, as well as other important long-standing protections that are fundamental to our robust public market system, she said. That's kind of what I'm designed for, the lawsuits. I used to work as a litigator in private practice. I used to be a trial lawyer. I also worked for the government as a special assistant U.S. attorney for 2 years. I'm used to tussling with large, complex regulatory and legal issues. That is, believe it or not, where I feel most at ease. What's been most challenging in a positive way is that this is still a very entrepreneurial environment. If I look back on my career, I've mostly stuck to the tried and true, traditional law firms, associate to partner, and traditional banks. So leaping off that cliff and starting a business was a bit of a gut check. But I believe in a positive way. Working for banks for as long as I have can be soul-crushing after a time. This has been both personally and professionally invigorating and rejuvenating. Ripple was rattled by the lawsuit. XRP's value has plummeted drastically. Coinbase, a major cryptocurrency exchange, has halted XRP transactions. Aldarity outlined Ripple's defense against the SEC's charges, the lawsuit's impact on the firm, and how this legal struggle might have a significant impact on the whole crypto and blockchain industry in an interview with Protocol. From a policy standpoint, I believe there are a few things policymakers should keep an eye on. 3 things come to mind. One is that there is a great deal of trading, both institutional and retail. As a result, you'll want to ensure that the owners of these assets are secured in some way, consumer protection. When you consider what the Clinton administration was able to accomplish with the internet in the mid-1990s, you can see how they recognized that they had an innovation with enormous promise. They didn't know what that enormous potential meant. They knew better than to regulate that fresh and developing technology with laws, rules, and regulations designed for rotary phones and transistor radios. 2. You want to keep bad actors out of this place as much as possible. Third, many people are concerned about the impact of many of these assets on the environment. And I believe that all 3 of these things must come together. And I don't believe that any single regulatory authority can bear responsibility for all 3. So, in my opinion, we need a cross-functional working group comprised of key regulators, namely the SEC, the CFTC, the Department of Justice, FinCEN, Treasury, and the industry, to sit down and work through a formal rulemaking or legislative process to see if we can arrive at a rational framework that balances regulation and innovation. As a result, you don't have any regulations that stifle innovation. There must be a delicate balance. What does all of this mean for the future of cryptocurrency? Many virtual currencies are now governed under CFTC laws, which are significantly less stringent than those imposed by the SEC. If the SEC prevails, it will have regulatory authority over many of the virtual currencies now traded. Because the technology was created to be independent of strong government rules, there's a good probability that this additional scrutiny will impede its development in the United States. Other countries would most likely take the lead in developing it. If Ripple wins, however, the CFTC's weaker standards will most certainly apply, allowing blockchain technology to evolve more freely. A potential disadvantage would be the lack of legal protections against illegal behavior, while many argue that the possibility of anything being used in a crime does not justify limiting honest use. What does the future have in store for us? It will have to wait and see. The SEC v. Ripple lawsuit is set to go through a long, and presumably messy, courtroom battle, and we're all waiting to see what happens.